Good morning, everyone. My name is Mike Wolf from the North Dakota Association of Counties and the County Employer Group. And first of all, I want to thank you for taking time out of your busy day to attend the webinar I'm doing today on payroll reporting, some rate allocations, splitting of rate classes, and some insurance coverage issues. I think there'll be some good information for you. I'm also recording this, and I will also be sending everyone the PowerPoint presentation afterwards that you can use for future reference as well, because there should be some good information in here that you should be able to refer back to. So we'll get started with our webinar today, talking about basically the North Dakota Workers' Compensation Insurance. North Dakota is considered a monopolistic state fund when it comes to workplace accident insurance. So that means that the only place coverage is provided is through the state fund workforce safety and insurance. In other states in the country, there's only probably about 6 states like North Dakota. In other states, private insurance companies can also write workers' compensation coverage. And workers' compensation coverage is a no-fault insurance. And what the trade-off is for employers is that the employee cannot sue the employer for a workplace accident. In return, claims are also accepted by workforce safety, even though there have been employee negligence involved in an injury that occurred at work. So the Workers' Comp Fund is trying to protect both the employee and the employer. So we'll talk about rate classifications through workforce safety and insurance. Workforce safety and insurance assigns rate classes to each employer in the state based upon the duties that the employee is performing. Now, when you see a rate classification of ours, it has a Z behind it. That means that those rate classification numbers and letters identify county employees when it comes time for workers' comp to do their statistics, and they can look at county employees specifically, and we can take a look at where injuries are occurring. And out of approximately 145 different rate classes, the CEG utilizes 16 of those on a regular basis. Now, rate classes and salary drive the amount of premium that is paid by the county. And the more hazardous the job, the higher the insurance cost is to cover that employee as well. Now, the dollar of each rate class is determined by the amount of premium that's collected statewide from all employers in those rate classes versus the amount of money paid out in claims. So when we have our road construction employees under 6042Z, they're lumped in with every company in North Dakota that does similar operations of driving heavy equipment. And workforce safety insurance will look at all the premium collected in that rate class, take a look at the money paid out in claims, and that's what drives the amount of that rate class. Then the dollar amount is assigned to the rate class by workforce safety insurance to a payroll cap per each employee. The payroll cap is usually the average annual salary in North Dakota each year. Currently, the payroll cap for 2020 that we'll be reporting wages on shortly is $36,400, and the payroll cap for 2021 will be $37,900. And generally, other states, employers in other states pay a premium based on the gross payroll that they expend versus North Dakota, where we have a payroll cap. Here are the rate classification descriptions that the county employer group utilizes. You may use some of these, you may use all of these. It just depends upon what operations you have going on in your county. I'm not going to go through every single one of them. I just wanted to provide you of the list of the ones we basically use that you can refer to in the future as well. And we're going to talk about a few of these classifications because they do have impacts on how you do report payroll. So we'll talk about the premiums. Premiums are paid on an annual calendar year basis. And what affects the premium each county pays? First, we utilize the rate classes that are being utilized, the number of employees in each of those rate classes, and then the salary earned by each employee in that rate class. And so employee turnover can also cause fluctuations in premium as well. So if you have somebody do a job for a portion of the year and then you hire somebody else to replace them, depending upon how much that goes on throughout the course of the year, could have a fluctuation in your payroll based on what we estimated that may be. And then each county is experience rated, and that can either have a positive or a negative impact on your premium. And we'll talk about experience rating in a little while. And then of course the risk management discounts after you pay your base premium based on the payroll that you expend and the rate classes that you utilize. Then through our workforce safety and insurance safety programs, you can earn risk management discounts as well to offset that premium, which is very beneficial to the counties. We have our drug-free and claims management discount that every county receives. And then we also have the learning management discount, the computer-based training discount that counties can receive if they're participating in the learning management system. They can get a 5% discount there as well. And I believe we have about 24 counties participating in that. And if there's any interest in participating in that, now is a perfect time because we're going to be starting a new year, and we could get started with that. So let me know if there's an interest there. And then also depending upon how much money our discount program or our safety programs and claims management programs save, we also have dividend credits that can be earned to help offset the premium that you pay to workforce safety and insurance. So here's some examples of some employee premium calculations so I can show you the different risks associated with the different rate classification. And generally, the higher the risk of the job means the higher premium that you're going to pay per employee, because that means workers' comp is paying out more money in claims under those rate classes. So if we had somebody who worked in the office 100% of the time and earned a salary of $42,000, we would be applying the payroll cap of 36,400. The rate for that is 24 cents per $100 of payroll. So that would be an annual premium of $87.36 for that employee. Now, if you go up to the traveling personnel, people who work in the office and out of the office with that same salary that would earn the payroll cap, that rate is 36 cents per hundred. So you can see it's a little more hazardous from a workers' comp standpoint than somebody who works in the office 100% of the time. And so that premium would be $131.04. Now, if somebody somebody didn't earn the payroll cap, then it's the premium is based on the actual earnings. So if they only earn $24,000, that premium would only be $86.40 a year. Now we get into law enforcement, we're going to get into a little more higher risk classifications. So that salary of $42,000 for a law enforcement personnel has a rate of $2.10 per hundred compared to only 24 cents per hundred for a clerical office worker. So the maximum cost for a law enforcement personnel would be $764.40 per year. And then we get into our road employees who drive the heavy equipment. This wouldn't be with any shop work involved. With that salary of $42,000, apply the payroll cap at a rate of $4.12 per hundred. Now we're looking at a annual premium per employee who earns the payroll cap of $1,499.68. So you can see that progression of hazard in the different rate classes according to the duties the employees are doing, the amount of premium that's being collected by workforce safety in each of those rate classes, and then of course the number of dollars that are being paid out in claims as well. So what's the importance of accurate payroll reporting? Accurate payroll reporting means you're paying the proper premium to workforce safety and insurance, which is really important because we want to make sure that you are not overpaying or you're not underpaying your premium. Because if we're audited by workforce safety and insurance, they can go back 3 years during an audit period and charge uncollected premium and interest if discrepancies are found, and they can assign penalties if they choose as well. So if we are audited by workforce safety and insurance, and if you have underpaid your premiums, because you didn't report them in the proper rate classification, that's very difficult for counties to have to pay those additional back premiums because there isn't budgeted money for that, right? Those years have come and gone, and those budgets are now gone, and they may not be allocated in the new budget. So that's why we want to make sure we're as accurate as possible to avoid any discrepancies where you might have to pay back premiums, penalties, and interest. And what's one of the biggest factors that would trigger an audit? This is probably one of the biggest things that really raises red flags with workforce safety and insurance. And I get calls on this every year, and they're usually pretty good about it with us because we have a good working relationship between the county employer group and workforce safety and insurance. But when an injury occurs, workforce safety will compare the job duties being done at the time of the injury, and they are going to go in and they're going to cross-reference that with what rate classification payroll was reported under. So if we have a law enforcement personnel that was injured doing law enforcement work and the county reported them under 8805, the clerical office class, that would raise a red flag for workforce safety and insurance because the wages weren't being allocated to the proper rate classification based on the duties that were being performed when that injury occurred. So that's why it's very critical that we get people into the right payroll classifications. So here's some payroll reporting guidelines for you, and this is something you can refer back to. And always know that I'm more than willing and able and happy to help you in any way if you have questions and concerns. And I do get a lot of calls each year during the payroll upload process. But the only people, and this is the biggest area we probably run into some problems with, is the only people that can be classified under 8805Z are people who work in the office 100% of the time. Now, the only exception that workers' comp is granted under 8805 is if a person goes to get the mail, they're allowed to go get the mail at the post office once per day. To pick up the mail. And if that's their only duty the whole entire year away from the office, and workforce safety has allowed for that exception. But if an employee who otherwise does work in the office 100% of the time, does leave the office even once or twice a year for any other reason, they must be bumped up to the 8747 professional business reps. That's our traveling classification where people would leave the office. We call them our traveling reps. So if a person who's in the office goes to a meeting outside the office or travels to a seminar even once per year, that's how strict workforce safety and insurance is on that, they need to be reported under 8747. Now, a lot of times we see elected officials such as commissioners, auditors, treasurers, etc., reported under 8805 clerical office, but those people all travel and leave the office, attend seminars, travel inside and out of the office, and they all need to be classified under 8747. And the thing to keep in mind is the small difference in premium between 8805 and 8747 isn't worth the risk of not reporting those people properly when you consider the penalties from workforce safety and insurance if they would discover that through an audit. So I always tell people, always call if you have a question, but if you want to err on the side of good judgment, I would bump them up to the 8747 so that they are properly covered and wouldn't raise a red flag with workforce safety and insurance in the event an injury did occur. And as I said, WSI is very strict about the 8805 payroll reporting. And so each year I usually get a couple questions from them, especially as it pertains to claims. So I mentioned experience rating a little earlier, and what is experience rating? And basically it's a number that's calculated by insurance companies such as Workforce Safety and Insurance and all private companies that provide workers' comp coverage to gauge both past cost of injuries and future chances of risk. So basically, the lower the claims cost for your county, the lower your workers' compensation insurance premiums will be because your experience rate will be lower. So workforce safety and insurance uses a 3-year period of claims costs when calculating your experience rate. So WSI calculates then what the expected losses should be for a county of your size according to the payroll expended and the rate classes being utilized. So the expected losses for Cass County are probably going to be much higher because they have many more employees than, let's say, a county such as Slope County, who doesn't have nearly the amount of employees working for them. So the expected losses will be higher for Cass than they would be for Slope. So what it boils down to is that if your actual claims costs over a 3-year period are lower than the expected claims costs, your county gets a discount on your premium. And if your actual claims costs over a 3-year period are higher than the expected claims costs, then your county is going to be surcharged additional premium. And workers' comp used to have a 5-year rating period for experience rating, and now it's a 3-year period, which is good for employers because if there's that big serious injury that occurs that expends a lot of money, or a death claim, which we've had in the past, that only affects your count for 3 years now rather than 5. So we start the budgeting process in July for the counties when you begin your budgeting process. So in July, we determine what your experience rate is going to be for the upcoming year. And then we calculate your estimated premium for the upcoming year based on a 3-year average of payroll expended. So your payroll may fluctuate. So that's why we take a 3-year average. And that's the most scientific way workforce safety has come up to determine what an advance premium should be at. So you can think of experience rating like your car insurance or your house insurance, basically. With your car or house insurance, depending upon how much you use it or don't use it. Usage of your car insurance tends for that to increase, and not using it allows you to earn the discounts on your premium that your car insurance would offer you. It's a complicated process, but that's kind of the nuts and bolts of experience rating. So now we'll talk about splitting payroll between rate classifications. Payroll can and should be split between rate classes if employees are doing different duties between 2 or more separate rate classifications. And in most of those cases, that can save you money. Okay, there are a few circumstances where payroll cannot be split, and this is where we run into some issues, especially with Clerical Office 8805. We cannot split payroll between Clerical Office 8805 and any other rate class. So if an employee does anything other than 100% Clerical Office duties, they have to be bumped up at least to the 8747. And I have an example where they would be bumped up to even a higher class in a minute. The other 2 classes are 9040Z and 9042Z, and those are nurses providing home services similar to hospital care. And the 9042Z is nurses or employees that provide outpatient services to county residents. So the county residents would come to see the nurses and employees in 9042Z, where under 9040, the nurses are providing home services, they're leaving the office, and that can't be split. So if nurses are leaving the office and doing inpatient or outpatient services, then they have to be under the 9040Z. So the only ones that can be under 9042 are those nurses providing people who come in to see the nurses. And how do you verify a payroll split? Basically, time cards is a good resource if we're ever audited. A lot of counties don't utilize time cards, but if they do utilize time cards, maybe sometimes the employees aren't allocating their time at the end of the day between the duties that they're performing. Some counties do that, and that's the best way to verify payroll splits. And then supervisor estimate. Okay, if you're doing the payroll report, you should check with your department heads to see if there's any possibilities of payroll splits for employees. And supervising using an estimate has worked for us in the past. For example, in our road department, some counties estimate that their road department employees work a portion of the time in the shop and a portion of the time working in the heavy equipment. And that split has been about 75-25, has been a good average split, where 75% of the time they're working in the heavy equipment and 25% of the time they're working shop duties, and we'll talk about that in a minute too. So here's some examples of splitting payroll. Last year we had several counties split payroll between 8805, and as I mentioned, that's incorrect. Okay, and also make sure the classification numbers are correct on your spreadsheet. Last year we had some counties had a classification 8852, which isn't even a rate class. Instead of the 8805, we had some classes like 8705 and 8714 that aren't classes, and those should be 8747. So try to check those, because if we don't catch those here, and getting a report with over 7,000 entries, that's very difficult to correct. So that report would get kicked out by Workforce Safety and Insurance as incorrect rate classes. So some payroll examples. We have this situation, and it does happen in our counties, where we have a female dispatcher who may be asked to assist with a female prisoner. I could be 1 or 2 or 5 times a year, not very often at all. Normally, she is only working as a dispatcher, and her wages would then normally be reported under clerical office 8805 if that's all she was doing 100% of the time. But since she assisted with a female prisoner, a portion of her wages need to be reported under 7720Z, the law enforcement classification, and then the rest of her wages would have to be moved into 8747, because remember, we can't split between 7720 and 8805. Okay, so then those remaining dispatching wages would have to be bumped up to 8747Z, and it's not going to have a big dramatic effect on the amount of premium you're paying, because we do want to make sure that's correct. And payroll can be split, even if it's only 1 or 2 times a year, and only a couple percent of their wages. If it's 1%, 2%, 3%, 5%, that doesn't matter, as long as there is some sort of a split. Because remember, if there's an injury when this female dispatcher is assisting with a prisoner, the first thing Workforce Safety and Insurance is going to do is check to make sure that wages were reported under 7720Z. So even if 1 or 2% of her wages are reported when she helped assist that, then that is going to be fine with Workforce Safety and Insurance, because they will see that wages were reported there. Okay, we've had situations in counties where a husband is a custodian and the wife has asked the county to be able to help, but doesn't get paid to help. So they might come in the evenings to do the custodial work, and the wife wants to help. There is no coverage for the wife, and if she were injured, you have to be careful, because she could sue the county for damages, because there's no coverage there. So my suggestion is either don't allow it, which would be my first recommendation, because now you've eliminated any potential possibilities or problems, or you cover her under a volunteer coverage account. Okay, and we'll talk about that volunteer coverage account in just a minute. But you want to protect yourself somehow in these cases where a situation like this might occur. We had an employee who worked clerical office during the day and then did janitorial work after regular hours, and the county paid them 1 salary for the entire year. So they reported wages under 8805 and 9007Z because they were doing office work during the day and then the janitorial in the evening. Now, because they paid a salary for the entire year based on all the duties they were doing, we can't split those wages with 8805. So the correct split would be 8747 and 9007, the janitorial class. Now, when it comes to risk managers, we have risk managers in every single location, and we have some risk managers who are in maintenance. So we got a couple people who are in maintenance who are risk managers. Now, those wages could be split between 9007Z, the time that they're doing maintenance work duties, compared to the time when they're doing their risk manager duties. Okay, this will definitely save you premium dollars. So you need to check with your risk manager, come up with a percentage of time that they're doing their regular maintenance duties versus their risk manager duties, and come up with a percentage split of that. And you can split those wages, and that will save you money. We have other risk managers that may be in the office for most of the year, but since they may leave the office at times for risk manager duties, they must be reported under 8747. So we might have some assistant risk managers that even attend training one time per year should be reported under 8747 if they're otherwise clerical office the rest of the year. But maybe that deputy risk manager or the risk manager who might otherwise be clerical office might go meet with another department outside their location, and our regular risk managers do attend annual training outside of their locations, outside of the office, so they would be 8747 if their wages otherwise normally would have fallen under the clerical office. So we had an employee too this past year that worked maintenance work part of the year, and then they changed to a clerical job later in the year. So a new job came open, the maintenance person applied for this new job and was hired for that position. So now in this case, there are two distinct different jobs being done by that employee. Okay, it's not a combination because that person gave up the janitorial maintenance work after they were hired for the office work. So in that case, you need to notify me so that I can let workforce safety and insurance know that we are going to list that employee under two different rate classifications, 8805Z for the time they started their clerical office, and for 9007Z before they started, before they quit their maintenance jobs. And if I let workforce safety and insurance know that, they will make a note of that, and then they will process the report accordingly. When it comes to road supervisors, a lot of counties report this road supervisor under 6042, which is the heavy equipment operation, and that's the classification that was $1,499, when generally a lot of their wages can be reported under 8747Z, doing general work. They might go out and check roads. That doesn't fall under the 6042 when they're driving their regular county vehicle to go check roads, check bridges, those type of things. But if they ever operate the heavy machinery to assist and help out in any way, then that portion of their wages should be reported under 6042. Or if they perform shop duties, that's class 3630, and those wages should be split accordingly. So there could be a three-way split for a road supervisor depending upon what duties they are doing for the county. Generally, the majority will be under 8747, and then there could be some other splits that go along with that as well. Road employees, generally the people that work 100% of the time in the heavy equipment are 6042Z, but if they ever perform shop duties, 3630Z, wages should be split accordingly. We have a lot of counties that do that. I know we have counties that still don't do that, and this can save you premium dollars. And a lot of counties, as I mentioned before, use that 75-25 split because you might have a winter like this winter. Okay, maybe the ground's frozen over and they're done driving the road graders and maintaining roads, but there's nothing else to do. So they're doing shop or work around the shop. They're doing vehicle maintenance, changing oil, doing stuff like that. And in those winters where they're not out driving snow plows, then those wages can be reported under 3630, and that can save your county money doing that. Weed officer is another area. A lot of counties report their weed officer under 0010, but generally they should be under 8747. Okay, because they might be going out and just checking the employees, checking the areas where they're going to be spraying. They're not actually applying the pesticides, and so that can be 8747. But then again, if they do perform any spraying duties, those wages must be reported under 0010, and so you can have a payroll split between that. But if they never perform any spraying duties, you'll save money by reporting them under 8747. So remember, with splitting payroll, any payroll split is pretty much possible as long as it doesn't involve class 8805, 9040, and 9042. Okay, and if you ever have any questions on where wages should be reported, number one, under what class, don't be afraid to ask. Or if you have any questions on splitting payroll, don't be afraid to ask. I'm more than willing to help. because we'd rather have it right than run into any problems later on down the road. Okay, now we'll talk about some coverage issues that come into play that it's really important for people to know who work in that area. A lot of that time that falls under the auditor's position. The risk manager, people refer and go to the risk managers a lot for information on coverage issues as well. And again, no, we're always here and available at the CEG to help as well. But if you have contractors performing work for the county, if your contractor is being done by any work being done by an outside contractor who has employees, you should request that they provide proof of coverage for workers' compensation coverage before allowing them to do the work. So if you're doing a remodeling project, if you're doing an addition project, if you're building a storage unit someplace and you hire an outside contractor who has employees, make sure that you secure their proof of insurance coverage certificate before you allow them to work, because if they don't have coverage and we find out they don't have coverage and one of their employees is injured, workforce safety and insurance can come back after the county as the general contractor for penalties and premium. So that's why it's important to protect the county by asking for a workers' comp proof of coverage certificate by an outside contractor who has employees. Now, if you have a self-employed contractor that's coming in, let's say you have a plumbing problem and you have John Doe, the local plumber, come in. He's a self-employed individual, has no employees. Under workers' comp law, self-employed individuals are not required to secure workers' compensation coverage on themselves. We recommend that they sign a document acknowledging they're self-employed and do not qualify for workers' comp coverage. That's the best way to cover yourselves. But if John Doe, the local plumber, is coming in to do your plumbing work as a self-employed individual, we've really not run into any problems like that because they have a distinguished business where they're providing a specific service for people. But you can still ask them, because a lot of those self-employed contractors do cover themselves under workforce safety and insurance. Okay, here's the volunteer coverage where we talked about the husband who was the janitor and the wife who wanted to help. Workforce safety and insurance provides volunteer coverage. So if your county has volunteers working for it, no matter what type of volunteers they are, whether it be a volunteer who works in your county library, or if it's this lady who helps her husband, or maybe you're doing emergency response exercise and you're getting volunteers to help come in to be victims and do that type of things. Workers' comp has a separate volunteer coverage account that we highly recommend that you get to cover those volunteers. And it's a separate account that Workforce Safety and Insurance provides separate from our CEG account. Okay, and this way it protects you if any injuries occur. The volunteer can sue the county for damages if there's no coverage, but if we have this volunteer coverage, that volunteer cannot sue the county for damages if they're injured. And it's very reasonable coverage. It's only a $250 minimum premium, which would cover 27 people as volunteers throughout the course of the year. If for some reason, depending upon the size of your county, you went over 27 people, it's only $9.06 additional for each over 27. Now, to work in conjunction with that volunteer account, a lot of counties, the courts impose community service and inmate work release sentences to people. And if you have people performing community service as a sentence from the courts, you should definitely be covering these people as well under your volunteer coverage account. Because this will protect you from liability if an injury were to occur. And we've had community service people doing sometimes dangerous jobs or potentially dangerous jobs. They don't necessarily come into the courthouse and do data entry paperwork. We've had community service people sentenced by the courts to work at the parks. Okay, now they're driving lawnmowers and operating machinery and those type of things. And those are areas where injuries could definitely occur. And so for this very cheap coverage, we can combine the volunteer coverage and the inmate work release and community service into one volunteer contract. Okay, so you could cover everybody, and as I said, you can cover up to 27 people throughout the course of the year under the same workers' comp policy. And I can assist you in getting that set up. You would have to set that up separately with Workforce Safety and Insurance. If you don't have it, I highly recommend it, and I can put you in contact with the people who you would work with to get that account set up. And when you think about this volunteer coverage and protecting the county against potential injuries from community service work and inmate work release, you couldn't secure insurance anywhere else in the country for the price of $250 and the protection you receive of, number one, not being sued, number two, providing that injured person, that volunteer, with 100% medical costs. And let's say in the case where we have the emergency exercises where people from the community come in to act as victims, if one of those people has a regular job and they get hurt during this exercise and they can't go back to their regular job because of that injury, this volunteer coverage policy also offers disability benefits to those people. And so you couldn't get a cheaper coverage to protect yourself. So if you don't have this, I highly recommend you, and I'd be happy to help you get that set up. If you hire somebody as an independent contractor and you really don't know whether they're going to be an independent contractor or not, especially if they don't have employees. If they have employees, then they need the coverage. There's no questions. But if a person is doing some work individually and you're going to be paying them and they don't have employees, and if there's any possibility they could be considered an employee under workers' comp statutes if an injury occurs, we should work with Workforce Safety and Insurance and get a written determination from them before allowing that independent contractor to perform duties. Okay, if there's any gray area, we should always get that determination to protect ourselves and we don't find out later that that person was really an employee and now we haven't paid premium on them. One area where we've run into issues too is employees working out of state. And we've communicated all of this information with counties in the past. But if you ever have employees working out of state, we may need to contact WSI to see if they will extend coverage or whether the county would have to get an insurance policy in the state where that employee is working. Now, travel to a different conference or a meeting outside of the state for a few days isn't an issue. So if you have a conference that the auditors are going to go to in Missouri for a few days, a couple days, that would be considered incidental travel. Okay, and Workforce Safety and Insurance would cover that. Now, issues that arise, especially and most recently, is when we have employees who attend a law enforcement training academy for an extended period of time. If this person attending a law enforcement training academy is going to be gone for 30 or more consecutive days, there is no extension of coverage through Workforce Safety and Insurance unless we get special permission from them. And each situation is decided on its own if they're going to grant us anything over 30 days. And in some of the cases, the county is required to purchase coverage in that state. Okay, so we really need to know if people are going to these training exercises. We just had a situation in the county where an employee was out of state for more than 30 days at a law enforcement training academy. The county didn't contact us so that we could contact Workforce Safety and Insurance. That employee was injured. The county filed a claim with Workforce Safety and Insurance in North Dakota, and they denied it because that employee was out of state for 30 or more consecutive days. And now, unfortunately, the county is going to be stuck paying all the medical bills associated with that claim for that injured employee because there was no coverage for that employee. So this is a really important part of our coverage, especially for our law enforcement facilities with people attending a training academy. So if your county will have a law enforcement officer that will be attending for more than 30 consecutive calendar days, it counts weekends as well, please contact me so that we can provide the following information to Workforce Safety: the name, the training dates, the dates they will be gone, the type of training, location, and those type of things. And then workforce safety insurance will make a determination, yes or no, whether that they will extend coverage. So the soonest you know about it, the soonest you should let me know, so we can contact workforce safety and insurance and get an opinion from them, because it may take a few days, a week, potentially, for them to get back to us in those situations. And then right after that happened to the county that didn't notify us that somebody went out of state for 30 days for a law enforcement, about 2 weeks after that situation occurred, then I did get a call from a county who said they had an employee that was going to be leaving the state for 20, it turned out to be 29 days. So I still like to get written verification from workforce safety and insurance, and they did document for us that they would extend coverage for those 29 days. And here's the statute as well that covers the out-of-state law enforcement training. Okay, and then coroners, this is really a unique situation that's come up in the past year. We've been involved with the CEG for 20 years, and 19 years went by before we had an issue with a coroner. And generally, counties are not reporting coroners as employees on their workers' comp coverage. So every county assigns a coroner. Okay, sometimes the county, we have a few examples where county employees, such as the sheriff, has been appointed as the county coroner, and that's not an issue because they're already an employee of the county. So their wages will be reported for both their law enforcement and their coroner duties. Now, if you are reporting the coroner as an employee, in this case as a sheriff, you would split the wages with Class 8747Z. Now, issues have arisen with counties who use a third party as a coroner, and that's the case in almost every situation, except a few where the county's appointing a third party. And if you use a third party as the coroner, you either must report that person as an employee or drop a contract as an independent contractor. We have some counties that contract with hospitals. Okay, and you should still put the agreement in writing with that hospital, indicating that the hospital is responsible for workers' compensation coverage. We just had a situation about a month or so ago where somebody was performing coroner duties for a hospital, and they filed a claim through the CEG. Okay, we protested that claim, saying that that person was an employee of the hospital whom the county contracted with, but there was no written agreement between the county and the hospital. And so we still did protest that. And in that case, workers' comp came back, WSI came back and said, yes, that person was an employee of the hospital who contracted with the county. But it would still be good to have that in writing ahead of time. If you contract with a mortician, the mortician in your county, you should still put that agreement in writing, indicating that he's operating or she's operating as an independent contractor and is responsible for their own workers' compensation coverage. And generally, they could be covered under their duties as a mortician too if they covered themselves under workers' comp. If you contract with an individual doctor or other person or other place, still put that agreement in writing, indicating they're responsible for workers' compensation coverage if that's how you're going to treat them, unless you're going to treat them as an employee, and then you could cover them as an employee under Class 8747, and it would be very minimal premium that you would be paying, but you would be assuming somewhat of a risk. And like I said, we've gone 20 years, 19 years without having any incidents with a coroner, and all of a sudden we had 2 incidents arise. And one of those 2 incidents that have risen was one where a county had agreed to services with an employee of a funeral home who was then injured performing coroner duties. And no agreement was in place with the funeral home or that employee of the funeral home. And workforce safety and insurance ruled that that employee of the funeral home was considered an employee of the county. And now the county is subject to past premiums and penalties as a result of that, because there was no agreement, or we could have at least gotten a determination from workforce safety and insurance up front that that person is either yes an employee or not an employee. So if you have any questions on the coroners that you've appointed in your counties, let me know so we can make some type of a determination as to whether they would be an independent contractor or an employee. And if you're considering them as independent contractors, always try to have some type of written agreement in place. And I'm assuming that your state's attorney can certainly assist you in drawing up that document. So we'll finish up today too by talking about some WSI changes for 2020 for the payroll upload process that we will begin here in probably about a week. We should have that ready to go in about a week. They've made two changes to the payroll upload process. One is no dashes in social security numbers any longer, and now a comma is required in salary. So WSI doesn't want the dashes in the social security number. So the previous way, you can see we were reporting with the dashes. Now that's incorrect. And the new one is just straight numbers across the board for that social security number. And then workforce safety now requires the comma in the salary. Okay, previous ways we report it was just straight numbers. Now that's incorrect. And the new way to report is with a comma in the salary item. So that will be explained too when I send out my letter. I usually send out a letter on the payroll upload process to all the auditors, and I will include that in my letter too, but it's good for you to make that note now that there have been those two changes. And also a reminder that the payroll for the human services, our social service employees, will be reported under a separate payroll upload on the CEG website. Okay, so you're going to have your regular county employees just like in the past. There'll be a link to upload your CEG payroll. And then our computer programmer is working on adding a link where you would upload the human service wages on our CEG website. So you'll actually have two separate uploads this year, one for the regular CEG employees and one for the human service employees. And the human service employee upload is for the state. We help assist the state human services department file their payroll report through the zones. So we will assist in that process, but just a reminder and a mention that we're going to have two separate uploads, one for regular CEG employees and one for the human services. Okay, so with that, that's all we have for today's training on this. I hope you found this information very beneficial. And again, as I said, if you have any questions, just let us know and I'd be more than happy to help you out. I do help counties do that, throughout the course of the year. If they have any questions or concerns, please call and ask so that if you do have any questions or concerns, we can get it straightened out way ahead of time before we submit that payroll report. And I'm checking to see if I had any questions here. And two questions I've seen so far was just emailing out the presentation. And I will do that for you. I'll send all of you the presentation. I'll send it to all the auditors and you can pass that on to whoever needs to get that. And then a question, will the host county be reporting for all counties in their zone, human service zone? And the answer to that is yes. So if you're a human service zone, you will be reporting a payroll upload for all the human service employees in your zone. So I should have 19 different payroll uploads for the human service employees. So I'm just checking to see if there's anything else here for questions. Running through my list of attendees. I really appreciate everybody who's attended today. I hope you found it beneficial for you. It's been a while since we did some of this, and there's been a lot of new people that do these processes. So I thought it would be important to go through this. So you can watch for my letter coming out to you in the next week or so, and we can start the upload process for the CEG and the human service zones. And again, don't be afraid to get a hold of me. Always more than happy and willing to help you out in any way I can. I don't see any other questions. If anything arises after the webinar, if something pops into your mind that you think you have a question about, don't be afraid to get a hold of me. My email is here. My contact email is here. I'll leave it up for a couple minutes so you can jot that down. I think most people have it already, but I'm always available to help out, answer any questions at any time. So with that, thank you once again for attending today's webinar. Please have a great holiday season and remember to stay safe. Thank you.